Good morning to everyone. Thank you for joining us today. It's Stratafin's first webinar of the year. Very exciting. Today we're going to be doing the topic revisiting POPI and PAIA policies as the CSOS implementation deadline moves. Just a couple of things. We are recording this webinar and we'll make the recording available as well as the free resource and the presentation template. We'll email it out to everyone after the webinar has ended and I've uploaded it onto the YouTube page. We will let you guys know as soon as it's available. If you do have any questions, you're welcome to put it in the question box. If there is time, we'll deal with one or two questions. We unfortunately won't be able to deal with all of them. So we will then take note of your questions and email it to each person with the answers after the webinar as well. I'm just going to put a poll up at the moment just so we can see what our audience is so that we can make sure we're explaining it to the right level of everyone. You can select multiple options in the poll, and I'm just going to leave it there for 2 minutes for everyone to select the answers. So thank you for everyone putting in their answers. I see we've got quite a lot of managing agents and portfolio managers joining us today, so welcome. I'm sure we have quite a few familiar faces with us. And then second most is trustees and owners. So we'll just ask the speakers to adjust their language and terminology accordingly. I'm going to be handing over to Willie Roos now, and he can take it away.
Thank you, guys. Welcome at Stratafin's first webinar for the year. Just some housekeeping. We've got the calendar with all our webinars out, and it is in general the first Thursday of every month. Tongue twister there for me. That we're going to do our webinars this year. It will also go on the neighborhood website as soon as that is ready from Zerlinda and her team, so that people can see when all the different webinars by all the service providers take place throughout the year. So yeah, that's that. Today we're going to have Dilen Heerschop joining me. Dilen is a legal practitioner of the High Court, specializing in law pertaining to community schemes and concomitant compliance issues faced by community schemes. He has conducted various seminars on behalf of the National Association of Managing Agents in respect of compliance and in respect of POPI. Dilen obtained his LLB degree with distinction, thereafter completed his LLM degree. Dilen has joined DTB Attorneys as a community scheme specialist attorney. DTB Attorneys is Stratafin's preferred service provider and panel attorney in respect of collections. Then we also have Veronica Bhengu. Veronica studied at the University of Northwest at the Vaal and Potchefstroom campuses and obtained her BA law degree and LLB degree. In 2018, she then completed the articles of clerkship and was admitted as an attorney of the High Court in October 2021. She started with Stratafin as an internal legal officer in 2020 and got promoted to legal compliance officer in March 2021. Veronica is also appointed as a director of Confiance Administrative Solutions in February 2022, where she administers sectional title schemes in distress and has had a huge success so far. So we've got these two experts joining us today, and I am in general going to leave it in their capable hands. all I want to say is that in terms of the POPI legislation, that came into effect in July 2020, June 2021. And then CSOS in a Practice Directive 1 of 2022 stipulated that POPI has to be and PAIA has to be complied with within 6 months from the date of this directive, and that directive was on the 10th of November, meaning that by the 10th of April, schemes should be compliant in respect of POPI. So in terms of Section 14 of the Constitution of South Africa, everyone has the right to privacy. The Protection of the Protection of Personal Information Act 4 of 2013 was enacted to promote an individual's right to privacy, including the protection of unlawful collection, retention, dissemination, and the use of personal information. So we're going to look at two topics today: the duty that community schemes have to protect its members' personal information, and then secondly, the measures that community schemes should have in place to prevent any liability or breaches of the POPI legislation. So Veronica is going to start by explaining to us the importance of complying with POPI. Thanks, Veronica.
Thank you, Willie. As a point of departure, if we can just remind ourselves of the Act, when it came, like Willie has mentioned, it came it was enforceable from the 1st of July 2020, and then a grace period of a year was given, thus giving it effect from the 30th of June 2021. And then all responsible persons were required to register their information officers with the information regulator by the 1st of July 2021 on the registration portal. So just a quick background of the Act and what has needed to be complied with thus far. So in terms of the Act, community schemes that are found by the information regulator to be in breach or in non-compliance with the provisions of the Act can face the following sanctions. The first one can receive a fine or a penalty not exceeding 10 million. The second sanction can be imprisonment, up to 12-year imprisonment of the information officer. And the third is that the person whose information was, whose rights were violated in terms of the Act, that person has the right to institute a damages claim and also to report the scheme to the information regulator. So with the sanctions that the Act depicts, we can see that the information regulator is taking compliance of the Act in a very seriously, and schemes are urged to comply as to not face the sanctions.
Can I ask Veronica, and maybe Dilen, you can also come in here. Do we expect that a scheme will be fined 10 million? I know that we're speculating here, but what is your, and Veronica, I think you can tell us what you think, and Dilen then what you think in respect of that. Do we expect, if there's a non-compliance with this, that a scheme can expect a fine to that tune?
I think the regulator would proportion the infringement and the breach with the person who did the breach or the organization who did the breach and the sanction. So I would not expect that a 10 million sanction will be levied for non-compliance, but Dilen believes a little bit different, and he can share with us. But I think the regulator would weigh up the sanction with the infringement and also the body in which committed the infringement.
Yeah, Veronica, I must say I completely agree with what you're saying. My advice always to my clients simply are that we should err on the side of caution when dealing with these types of legislative fines. So as we know, the information regulator has to date not issued a single fine or enforcement notice giving us any guidance as to how they get to this figure of 10 million rand. So I always see this as any non-compliance with POPIA until we have certainty can be seen as a 10 million rand fine, and we should really err on the side of caution, because I mean, I don't personally believe that any community scheme has enough funds to enable them to simply pay a 10 million rand fine and to continue with business as usual.
So from that point of view, you would say, well, rather be safe than sorry. Make sure that you comply rather than being in a situation where you have to try and get a fine from members, and in all probability will have to raise a special levy to pay for a fine from members.
That's correct.
Yes.
Okay, moving on to the applicability of the Act. So the Act specifically finds application within community schemes, and this is for two reasons. Community schemes are processing personal information, and as such, they enter this personal information into what the Act defines as a record. And I'll illustrate in a very simple example. Requesting a new owner who has just had their property registered to complete a form which they require to fill in their name, their surname, their cell phone number, and email address for the purposes of entering that information in the biometric system. So we can identify that there's processing of personal information. This is the physical taking of the information on the form. Secondly, the information that is on the form is personal information as defined by the Act. It's a name, it's a surname, it's a cell phone number, and an email address. And the record element would be entering this information into a biometric system. So that example illustrates how community schemes find applicability within the Act. And therefore, community schemes are required to comply with the provisions of the Act. We can move on. Then we deal with the element of processing. So I will identify each activity that's related to processing and also give a practical example within the community scheme industry that will find application. So the first one will be collecting. Like I said, requiring an owner to complete a form with their details once they've entered or become a member of the body corporate. That's collecting personal information. Creating personal information would be to create a unique identification code, perhaps, or to create a code to enter the complex for a visitor or a tenant or the owner themselves. That is creating personal information. Utilizing personal information would be needing to call the owner, SMS the owner to notify them, for an example, about a Wi-Fi breakdown or the fiber being installed or the electricity going out for a few hours. That will be utilizing the personal information. Storing the information, we also see this required by Prescribed Management Rule 27.2, where the regulation requires community schemes to keep certain information of tenants, of trustees, and also storing personal information into a software that a managing agent might use. Sharing of personal information, this, as an example, if maintenance needs to be done on a specific unit, the managing agent would receive that request from the owner, then the managing agent would send the maintenance team to attend to Unit 17's water valve replacement. That's sharing of personal information. Obviously, the maintenance team needs the information so that they can fulfill the request of the owner. Retaining personal information is also seen in the prescribed management rules, a requirement for community schemes in prescribed management rule 27.2 once again. And then destroying would be where destroying of personal information would be when an owner has unbecome a member of the body corporate or of the community scheme, and therefore there's no need to keep the information on the levy book or on the system to disseminate levy statements. So that would be some practical examples of what processing of personal information is. And from the examples I've just given, you can see that community schemes are processing personal information. Okay. The next question.
Sorry, Veronica. So what is personal information?
All right, so we can see a very full and comprehensive description of what personal information is in Section 1 of the Act. And this includes, but it's not limited to, the full names and surnames. This includes identification number or registration number if an owner or an owner is a company or a private entity, the age. It can be the physical address, contact details, religion, sexual orientation, etc. And also cell phone numbers within the contact information realm, email addresses as well, next of kin information. That is all personal information. Okay. Now moving on to entering of the personal information in the record. So in the beginning of my presentation, I spoke about a biometric system, which I think all community scheme managing agents, trustees can relate to. So this is a form or a medium in which personal information is stored or captured. So that personal information can be you asking owners to fill out forms. That would be a written record, and also digitizing or computerizing that record, taking the information you've received from the owners and physically typing it into a digital platform or a computerized record. This can be, like I said, a biometric system. It can also be software that the managing agent uses to manage their complexes for the sending out of statements, AGM notices, sending out special general meeting notices. So the way in which the information is being stored will allude to the record. So that is the record. And by this, we can see that community schemes, once again, have direct applicability with the Act, in which they are processing, recording personal information.
Thanks, Dilen. Will you deal with POPI's conditions for processing of personal information for us?
Yes, thank you, Willie. So I am aware that we have had a webinar, or Stratafin has had a webinar where we've actually discussed all of these components in quite some detail. So on a very high level basis, I just want to touch on the conditions of lawful processing. So the first condition is accountability. And in essence, what accountability means is the community scheme is responsible for the personal information that it holds. This accountability even extends to third parties. So even in situations or instances where we now transmit this personal information to, for example, a managing agent or any service provider, we remain accountable as the responsible party for this personal information that we have. So to boil this, yes.
Yeah, can I just jump in here? So on sectional title Living South Africa, I've on many occasions says that if somebody asks for information, you must, as a trustee or the managing agent, you should ask what the reason is why this information is required. And if somebody says to you, I want to use it because I want to go and get support, I want to get 25% support from owners because I want to call a special general meeting. In my mind, that would be a legitimate cause for you to actually get that information. And from an accountability point of view, if you've asked a question and you got an answer, and that was the answer, would you then be held responsible if you gave that information under those circumstances? What is your point of view?
So this, I think we're jumping the gun a bit, but this relates more to processing limitation, which is the justification for why we are actually processing personal information. But to answer your question, whenever we process personal information and it is in a justified manner, such as the Act actually requires, or the Act vests this right of access to information because this owner is entitled to this information, provided that this information is used for that purpose, for the purpose I want to call a meeting, or I want to send some or other newsletter out to try and establish a quorum, that would be fine. In those circumstances, there would be no breach of POPIA. But what I always suggest in circumstances like this is that we get an undertaking from this owner that the moment that that purpose for which that person processed the personal information, so they have now sent out the newsletter or whatever they wanted to do, After that instance, they need to actually now take the steps to destroy that personal information. So the moment that extends, that is where the whole pickle comes in, and where the accountability may then come back to the body corporate or HRA.
And to add on what Dilen said, if that owner now uses the personal information obtained for the legitimate purpose that was established for another reason, then that act of using that personal information, for an example, to sell Tupperware, would then be a breach of the POPI Act.
So
Absolutely
that person will then be liable to a fine to the tune of 10 million or the 12-month imprisonment and so forth.
That's correct.
Okay.
From the second condition being purpose specification, I think we preempted this to an extent as well, is that the purpose of the processing activity needs to be clearly defined. So there needs to be certainty as to why we are actually processing personal information. So a common example of this in a community scheme context is, why do we have personal information of all of our members? Well, the simple answer is Prescribed Management Rule 27 requires us to actually process this personal information. So we need to ensure that we define our purpose within the parameters of the sectional title or the company laws of South Africa, depending on the nature of the scheme. And then what we must understand is, after we've defined this particular purpose, we are only entitled to process personal information for this specific purpose. So for example, as Veronica has mentioned, now the trustees decide they're going to try and sell Tupperware. That is not the purpose that we have this personal information. So it's quite important that we actually specify why we are using this personal information. From the next condition being openness and transparency is one of the conditions, and this relates to the fact that we should actually inform these data subjects being any person whose personal information we process. So this can be managing agents. When we have their details, it can be members and owners. When we have their details, it's tenants. It's when we have service providers details. We should inform them by way of notification that, listen, we actually process the following personal information. The reason we process the personal information is we will only transmit personal information to whomever on these circumstances. So there is this notice requirement, and we have to convey a notification to all of our data subjects where we inform them of the fact that we're actually undertaking this processing activity.
Sorry, Dilen, I just want to, whilst we're on this, I see that there's a question by Samantha Wobson. I think that's my eyesight's going. I mean, old age is catching up to me. So she wants to know, she works for a retirement village, which obviously is also a community scheme, and she wants to know if the residents' telephone numbers and names can be circulated to all the other residents. So from what you and Veronica have been saying is, I would think that you would not be able to just circulate that as a matter of course, but you would want to know why people would require this. It must be a legitimate reason and so forth before you circulate that. Is that correct?
Yeah, so the big thing is, I don't think as a blanket we should just give everyone access to all of the information. We must remember that each and every individual whose information we hold has this right to privacy and is entitled to have their personal information protected within the confines of POPI. So whenever there's a request, for example, unit number 1, there's water coming out of his door, we don't know why, there might be a burst geyser, can I get his cell phone number or her cell phone number to contact them? That might be a reason, but just as a blanket statement, I don't think we can just simply circulate a list with all of the owners' numbers to the other members.
Okay.
100% agreeable with Dilen. And I think the belly of POPI is reason. There has to be a legitimate reason for the request or for the processing. So I definitely share the same contentions as Dilen.
Okay.
And
Then
just one last question at this stage. If the managing agent makes information available that is being held on behalf of the scheme to the trustees, and the trustees then make this available without requiring compliance with POPI, what is the risk involved for a managing agent in that respect?
So the big thing is, what we need to understand is that managing agents normally act on the instructions of trustees. And I think this is something that we've heard far too many times. And I know we've had webinars on where we've discussed the fact that we want to professionalize this relationship and start moving away from this agent or master and servant situation. But for now, as I've mentioned, accountability will remain with the community scheme. So the moment there's an instruction, listen, send out this information to Mr. A, B, or C, then the accountability is going to remain with the community scheme. And my suggestion always, and I think like I always get these ideas on the fly, but my suggestion in these regards are always that we get an undertaking from the particular person who's getting this information. I mean, we can dot down that you're only allowed to use this information for this reason, the reason you requested it, and after that we want a confirmation that you have in fact deleted this information.
Thanks. Won't interrupt you again.
Then the fourth condition is processing limitation. And I think this is one of the most important conditions. Like if there's one thing that you take home or take away from this webinar, it would be this particular one. And this is the justification in law as to why we are entitled to process. So POPIA prescribes quite a few justifications or reasons for processing personal information in law. But the ones that bear relevance to us is, firstly, we are entitled to process personal information as a result of a statutory obligation. So, for example, the prescribed management rules oblige us to keep a record of certain information in relation to tenants, members, and trustees. So the Act actually obliges us. So that's a justification. We're complying with the sectional title law, or we're complying with the company laws. Another one is that we have a contractual obligation to process personal information. So this relates a lot to HOAs as well, where our memorandum of incorporation or our constitution actually makes provision for the fact that we need to process certain personal information for the purposes of administering this community scheme. So that is the next one. Another one is legitimate interest, and this is a very hot topic. We've reserved a whole slide so that we can have a discussion in relation to legitimate interest. So just keep a knot in your ear here. We will chat about that. And then the last one, and probably the one that we've heard the most, if we can just move back to the previous slide, apologies. The last one is consent from the particular person who we now want to process personal information. Before I move on, I just want to mention something. I've heard this question a lot. I've seen it in emails. I've addressed it a plethora of times, to be honest, is where there is a form of saying, I did not consent to you processing my personal information, so please, you are not entitled to. What I want you guys to understand and take from this webinar is the moment we have a different form of justification. So for example, we have to comply with the prescribed management rule 27. That is our justification. We're complying with a statutory obligation. Then the need for consent falls away. So whether or not that owner is happy or sad or angry or whatever the case may be, they are then not entitled to say, I did not consent to the processing. And from a community scheme's perspective, we have justified it in law. The Act requires us, or a contract, the MOI or the Constitution requires us to process. So in those circumstances, a owner's consent is neither here nor there. And in those circumstances, we don't need to give effect to the fact that they're saying, please delete, we didn't give consent. Because I think that's an excuse and something that a lot of managing agents have encountered, and it's simply not the case. So then The fifth condition is further processing limitation. So this is actually very interesting, and it relates to secondary processing. So before we start dealing with the further processing limitation, I just want you to understand what secondary processing means. So the second condition, as I mentioned, was purpose specification. So we've now specified we are going to process your personal information for reasons A, B, and C. Whenever we start processing personal information for any other reason, that is seen as secondary processing. So the moment we again have a situation where we're processing for any other reason, that is secondary processing. And what the Act actually says, before we are entitled to now process for this different reason, we need to again go back and comply with condition 3. So we have to send another notification to the owner or to the person whose personal information we're now trying to process on a secondary fashion, and tell them we are now, in addition to the previous notification, we are now also going to process personal information for reasons D, E, and F, for example. And then secondly, we again need to justify that processing activity within the confines of a processing limitation. So we can again going to have a look at whether or not there's a contractual obligation on us to process for that secondary purpose, or there's a statutory obligation. And where these things are not the case, then we're going to have to seek consent. Now, a common example of further processing is, for example, WhatsApp groups. I think a lot of schemes have WhatsApp groups, and I think all of us can agree upon the fact that when we have a look at the sectional title law, nowhere does it say in the Act, listen, you have to have a WhatsApp group and everyone needs to be added on the WhatsApp group. So in those circumstances, normally it would be seen as a form of secondary processing, because we're now utilizing this personal information that we have in terms of the Act for a different purpose. When we're doing this, firstly, we need to send out a notification. Listen, we are going to create a WhatsApp group, or we have a WhatsApp group. If you do not consent, because as I said, there's no reason or justification within the sectional title law or any law saying that we need to have a WhatsApp group, and then we need to justify it again by seeking the consent of the member. Then from an information, can we please go back again? Sorry, I'm at number 6. Condition number 6 is information quality. So there, the information that we have must be of a good quality and free of errors. So this is quite a difficult one from a responsible party or community schemes perspective. I mean, ultimately, we only have the information that the members or the tenants provide to us, but we still have this obligation to ensure that the information is of a good quality. And my suggestion always with this information quality component is that on a 6-monthly or yearly or 2-yearly, depending on when you guys decide how often, we need to again try and verify the information. So again, send a blank information, owner information sheet, and ask them to delete it or to update it or to inform us if there's any changes, because ultimately we remain obligated to have information that is of a good quality. Then information security, this is also an important condition for lawful processing. What the Act says, in order for us to avoid the unlawful processing of personal information, we need to adopt technical and organizational measures to try and avoid the unlawful processing. So from a technical perspective, technical measures are seen as such as firewalls, password protected stuff, antiviruses, all of those IT things that I'm not too good at explaining, but all of the types of IT things that we use to try and protect the personal information that we have on electronic platforms from that it leaks or that it gets out or gets into the wrong hands. Then from an organizational perspective, this relates to your staff contingent or the individuals who will now have access to personal information. So we have to have a policy in place how we deal with personal information. We have to give the individuals who are actually on a day-to-day basis utilizing this personal information, we need to give them training. We need to allow them or put them in a position to actually process personal information within the confines of POPI. So today's session is a form of an organizational measure. We are now conducting training to actually further ourselves and to understand how we should handle personal information within the confines of POPIA. And then the last condition of lawful processing is data subject participation. So this is only the rights that these individuals have. So they've got a few examples of the rights that you have in terms of POPI. You have the right to request that your information be updated when it's wrong. So if you see it's wrong, no one can refuse to update your information, so to align it with the actual information that's right. And then another example of this is you have the right to ask someone to delete personal information, but let's not forget the discussion we already had where I said that as a scheme, if we do not justify based on consent, consent is not relevant. So then we've already justified it based on something else, and then this right falls away because we're not using that to actually justify the processing of personal information. Now, I think we've tried it a few times, but I think we can move on now to the next slide. So this is also a very interesting topic, and I think there's a lot of views on what we should do and how we should do it. So this relates to the balancing of interest, and I want to focus in on Prescribed Management Rule 27 versus this right to privacy. I mean, we've had this discussion for a bit now, where we said how we should protect everyone's right to privacy. But when we have a look at Prescribed Management Rule 27.4, it entitles an owner to inspect a list compiled by the community scheme, which includes various personal information of members. This includes personal information of tenants as well, and of trustees. And when one reads Prescribed Management Rule 27, it creates a lot of confusion, because Prescribed Management Rule 27 says, upon a written request or upon a written application, the body corporate must. And they quite clearly use the word must. So when one then looks at Prescribed Management Rule 27, it seems to suggest that there is no discretion when dealing with this request. The moment we have a request, we must simply provide this information. And just to inform everyone of the stark reality, that is not the case. We cannot do that. So that is where we now discuss the aspect of balancing of interests. So just from an interest sake perspective, Prescribed Management Rule 27 vests an owner's right to access to property. So it gives them the right. That's all it does. But PAIA, the Promotion of Access to Information Act, it actually regulates how we get access to this. And I think that's where the confusion arises, is because we blindly rely on Prescribed Management Rule 27, whereas this actually simply vests the right. So what we should in fact do, we shouldn't blindly provide them with information. We should do a balancing of the members' rights. So we're going to have to balance the individual owner's rights to privacy with the member who made the request's right to access to that record. When we do this, we need to understand why the sectional title laws were enacted. And I mean, I think the Act itself suggests what it is: Sectional Title Schemes Management Act. So the Act was enacted to further the management and administration of a scheme. So when we get a request, we're going to have to decide, does this request in fact further the management and administration? If that answer is yes, we provide them with the information. If the answer is no, we don't. So just to give you an example, and I've mentioned it, the unit above you is flooding. I need the person's number so that we can mitigate the damages that has already occurred. That's an instance where it would further the management and administration. But for example, I'm going to the AGM next week, and I want to know who of the tenants or of the members are in arrears because I want to name and shame them, for example, at the meeting. That does not further the management and administration. And I mean, from a practical perspective, I think the embarrassment may further the management and administration, but that's simply not, from a lawful perspective, it doesn't make sense. So practically it may further because they may pay after the name and shaming, but simply that cannot happen within the confines of the right to privacy. Then we're also going to have a look at legitimate interest. This, as I mentioned to you guys, is one of the justifications as to how we can process personal information. So basically what legitimate interest is that there is a common interest between all of the individuals in a scheme, and that is a legitimate interest. So as soon as we start doing things that is in the common interest of all of the members, and I mean, we'll get members that say it's not in their particular common interest, but in the common interest as a whole, we are then entitled to, for example, process personal information. So what can possibly be seen as a form of legitimate interest? So one of the interesting components is the taking of CCTV footage. I think there has been quite a hefty debate on the taking of CCTV footage as well. So, for example, if the community scheme decides they are going to start a Big Brother community scheme edition, where they simply live stream the comings and goings, and any person on the internet is capable of connecting to these cameras to go and peek and see what everyone's doing. Naturally, that does not fit the common purpose of all of the owners. That's ultimately the gist of it. But for example, if we have capture CCTV footage at the gate and at the perimeter fence, and perhaps in the common property where the parkade is, so that we can try and avoid crime and avoid damage to property and to one's person, those are seen as a common goal or common purpose of owners. So that is also a form of processing personal information, and that is then justified based on legitimate interest. My advice always, when trying to justify things with legitimate interest, we should again err on the side of caution. The Act does not per se say legitimate interest means A, B, and C. It was left open-ended, and this means the information regulator will ultimately have the discretion to decide what is seen as legitimate interest. And again, as we have no certainty how the information regulator intends to apply POPI, we should really err on the side of caution when trying to justify processing based on legitimate interest. So just from a more practical perspective, I mean, it's all good and well. I give you these philosophical principles, but we want to touch on the actual implementation of a POPIA champion program, if I can call it that, to try and ensure that we in fact comply with POPI. So one of these requirements is then that we need to conduct a gap analysis or a personal information impact analysis. So what will we have a look at? We are going to have a look at which personal information we process as a scheme, the purpose of such processing. As I've mentioned, it's very important, and it's the underlying theme for POPIA is that we need to have a purpose. Who is going to process this personal information? And then also we're going to have to have a look at the existing protection measures that we have to try and protect this personal information. And why are we evaluating this? To achieve the ultimate goal. So what is the purpose of this analysis? So that we can anticipate possible compromises in this processing process, and then also to implement appropriate preventative measures to prevent this. And I feel like an insurance broker when I say this, but in these circumstances, they want us to be proactive rather than reactive. I mean, they don't say your first contravention, you're going to get a warning or a slap on the wrists, and the second one is 10 million. From the outset, it's 10 million. So they want us to be proactive and to try and anticipate where we have shortcomings in our practices with personal information. And coincidentally as well, this gap analysis is our free resource. So we've drafted a basic version of a gap analysis so that we can see how this looks. So there's the example. And as I've mentioned, these are the types of things that we're looking at. So what information are we collecting? Who has access to this? What is the purpose of this processing activity? In which format is it stored? Is it stored in a trustee's black book where they write everything out with their hands? Or is it on an electronic? How are we storing it? Are there existing safeguards? So for example, if it's in a hard copy in a file somewhere? Is that file in a file cabinet? Is the file cabinet locked? Who has access? These are the types of things that we can look at to try and anticipate possible breaches, or is it simply lying on the estate manager's desk and anyone who goes into his office has access to this? Then, is it stored or backed up? Who has access to this information? Foreseeable breaches, do we encounter that there's a possibility that if something happens, there's a breach? And then the ultimate conclusion that we'll reach is the preventative measures that we are now going to implement in an attempt to ensure that this does not happen in future, or to prevent breaches in its entirety.
Fantastic. Dilen, a couple of questions has come up throughout the webinar, and then also, and we don't have too much time because I know that we're going to go in load shedding at 12, so we need to make sure that we finish by 12. But there's a couple of questions that came in on the questions, and then also people have sent in some questions. So I want to deal with a couple of those, and if we can maybe get your points of view and maybe Veronica's point of view. Pearl, hi, how are you, Pearl? Pearl has asked, has it become time for schemes to start insuring themselves against this risk? I think Michael Addison should have been here to answer that. From my point of view, I would think that it's a prudent thing to do, to insure yourself, but obviously then the rules also require how one have to get permission to insure anything else that you want to insure as a scheme that is not required by the Sectional Title Schemes Management Act. So you will have to take through that process in an AGM. Then here's a question about managing agent withholding information to the directors or to the trustees. Are they entitled to do so? Dilen, maybe that's something for you.
So my view on that is that the managing agent, as we've said before as well, they are part of a master servant agreement. So I can't see how a managing agent is in a position to have access to that, but the direction or the scheme executives are not. So in my view, scheme executives are entitled to this information as long as they take the necessary steps to safeguard it. So they're not in a position to sell Tupperware by using that information, but whenever they are now busy with certain things, they have access to this information.
Absolutely. It is almost the tail wagging the dog, hey. Until such a time as managing agents are professionalized and is a profession, and then takes over that fiduciary responsibility towards the scheme, at the end of the day, it's still the trustees that have that duty, and the managing agent actually reports to those scheme executives. Veronica, schemes that have not registered their compliance officer, can they still do so?
Yes, the information portal, the information regulatory portal is still open for schemes to register their information officers.
Okay, and then Gerard says that our introductory comment was a bit incomplete. Sorry about that. He says that on the 10th of November, CSOS Directive 46 states that the POPI manual must be adopted by members at a special meeting or an AGM within 6 months. Thanks, Gerard. I think that's
yeah, something on that what I want to mention, and this question has come up. Who needs to adopt this policy? And in our view, and this relates to how the Sectional Title Schemes Management Act is written, this relates to day-to-day administration. This is a thing, how will we on a day-to-day deal with someone's personal information? So I'm struggling to find understanding as to why we should approve this at an SGM or AGM. I mean, let's make it a unanimous vote whilst we're busy trying to put these restrictions on everyone. But to my view, this is a day-to-day administration issue, which means the trustees will simply enact it. It's trying to expect that a shareholder in a normal conventional company, so me having shares in Coke, must now go and vote at Coke's meeting so that they can enact something which relates to day-to-day administration. So it is a bit confusing and ambiguous, and I can't seem to agree with it, but be that as it may, that seems to be CSOS's view on this particular situation.
Yeah, I think one of the questions that you and I have discussed in preparation to this was the regulation by CSOS and how enforceable is it, and maybe you can share that discussion that we had regarding that.
Yeah, so basically, the information regulator is the only party who is authorized in terms of POPI to make decisions such as we are extending a grace period, or we're giving you this grace period, or you can register by then. So to my view, CSOS can really not be in a position to prescribe a particular date. This does not necessarily mean that we should not comply. From my view, we should have been compliant from the 1st of July 2021. I mean, that's when POPI came into effect, or these provisions came into effect. So we should have been compliant by then. But I think what CSOS's intention with saying that might have been is that they may now start managing these situations. So they're going to start asking for POPI and PAIA manuals and trying to ascertain whether this has happened. So they don't have the discretion to decide by when we should be compliant. But I mean, ultimately, as the upper guardian of all community schemes, they can go and have a look and do an audit of sort to try and ensure that everyone's house is in order.
Yeah, they can also not determine what type of vote is required to actually adopt this manual, like what you said earlier on. So they can't say it's a unanimous resolution or special resolution or whatever the situation. The law is the law, and there must be compliance to that, and they can't change it with one of their requirements. They can't just make a requirement in that respect.
Exactly that, Willie. It's a very interesting thing, and I think there will probably be a lot of debate. I think a few people may take CSOS on this particular thing and their interpretation of POPI and how they try and implement it, but only time will tell. Let's see, maybe the courts can give us the certainty that we don't have at the moment.
Then there's a question about tenant information, caretakers collecting tenant information. Now, we also are aware that the Sectional Title Schemes Management Act and the prescribed management rules require that a scheme does have details of tenants. So from that point of view, there's also a right to have that. So a scheme is entitled to actually keep that information as well.
Yeah, and whether or not the tenant elects, sorry, Veronica.
No, you can continue, Dilen. Thank you.
That, as I said, ultimately we are entitled, and whether or not the tenant wants to give that information, we must have it. And I mean, practically speaking, why do we want this information? So now the owner sits in Timbuktu and something's happening to his flat. We need to be in a position to try and contact someone. And that's the whole purpose of it. It's not because the lawmakers thought, let's be clever to include this provision. There's actually reason behind why we need this information. So yes, we need to process it as a community scheme. And yes, we need to ensure that that information is correct and that we have it readily available.
Veronica,
we also need to remember, yes, that these caretakers are employees of the body corporate. So they're exercising a duty within their responsibility and their mandate from the body corporates. So sometimes it's seen as that the caretakers arbitrarily collecting this information, but it might so be that it is one of their responsibilities and forms within their job tasks and job responsibilities.
Absolutely. There's a question about how far does your right to information go? Are you as a member entitled to, for example, the bank statements, bank balances, who's in arrears and so forth? I don't know. So yes, the two of you.
I think I'll start and then Veronica can finish my sentences. But my view on this is you are entitled to these types of information. POPI says that the moment that we de-identify personal information, that information is no longer protected within the confines of POPI. So for example, let's say they want the financial statements and the arrear levy accounts. When we send those types of things to them, why do we need to include the person's email and how a conventional levy statement looks with their address and the person's name and their cell phone number and email address? That might be seen as a breach of POPI. But the moment we take the measures to de-identify, so for example, we only leave unit number 1. That's the only thing that's on the statement, and the rest has now been redacted or scratched out or whatever you want to do to try and protect the rest of the information. Then that information is de-identified, and then you are entitled to transmit this personal information.
From my side, as a sectional title administrator, I believe that owners have the right to access the full information of the body corporate, but also to protect the personal information of owners. For an example, if we are having a meeting, an owners meeting, and we need to reflect to all the owners the financial situation or the age analysis of the body corporate, will then go and de-identify the personal information by redacting the unit numbers and the owners' names. And also portals that we use to upload information of the body corporate should not contain specific personal information of owners, and that's the responsibility to protect the information. So it must not misconstrue the right to information with the right to personal information. So we must just be very careful in identifying the two.
Absolutely agree, Veronica.
100%. Ladies and gentlemen, there's still quite a few questions that we have not answered. What we will do is we will give it to Veronica and to Dilen to answer, but we unfortunately have run out of time. So thank you for joining us again, and we will hope to see you again. Thanks, Veronica. Thank you, Dilen. We really appreciate your knowledge and expertise in this regard.